Good afternoon, Monica Miller here, Legal Director and Senior Counsel for the American Humanist Association. This is Legal Tuesdays, where I answer your questions about separation of church and state. So the first question I will get to was from our new online forum for Legal Tuesdays specifically. Dustin Daniels says, I'm enrolled in a local community college and recently noticed that the Director of Human Resources gives the same invocation at the commencement every year and wants to know whether this is unconstitutional. Generally speaking, yes, it should be unconstitutional. The Supreme Court in many cases has said that the government cannot endorse prayer at public functions. You can't have government employees leading prayer, especially at an event for a graduation. The Supreme Court in Lee versus Weissman, a 1990s case, said that even a non-denominational prayer at a voluntary graduation, that case involved middle school and high school graduations, was unconstitutional. And shortly after that, in the early 2000s, the Supreme Court in Santa Fe versus Doe versus Santa Fe rather, ruled that even at completely voluntary public school events such as football games, it's unconstitutional for even genuinely student-initiated, student-led prayers to be delivered. So although the court hasn't yet addressed the higher education level for graduation prayers, those two cases combined with all of the other Supreme Court cases on prayer in government settings and in public schools specifically would suggest that this is not allowed. There is a very narrow exception that the court has carved out for government prayers in the legislative setting, but this particular prayer I don't think would pass muster under those Supreme Court precedents. For one, it's a public school employee giving the invocation in the scenario that you've described. It's not an outside community member. So in the Town of Greece case that the Supreme Court upheld under that legislative prayer exception, a community's prayer practice in which outside community members on a non-discriminatory, neutral basis were allowed to come in and deliver an invocation to open up these town hall meetings. The court said that because even an atheist could give an invocation under this town's policy, there's no evidence that they were excluding any particular faiths or people from that practice or that opportunity. It was upheld. This is a scenario where the same prayer is being given by the same government official every single year. That is a different problem. That goes more towards the Supreme Court's cases saying that governments can't endorse prayer. And even in the Town of Greece case, the court talks about how there's a difference between an outsider or a chaplain giving the prayer, where you don't affiliate the prayer with the government, and the government itself giving the prayer. And cases in the circuits post the Town of Greece decision have generally come down on the side of saying that yes, a prayer, if it's from an outside community member, is allowed. No, it can't be given by the county officials themselves. So with that being said, there are several circuit court rulings that have gone the other way. Those rulings do predate the Supreme Court's Santa Fe decision, which said that even completely voluntary events like school football games, you can't have a prayer being given by even a student. Because it's too coercive and there's too much endorsement by the school at an event that's hosted by the school. It's using the school's loudspeaker. Everyone's there, in school colors, and it's a school event, so it would have the aura of school endorsement, even if it's delivered by a student. Those two rulings were from the 6th and 7th circuits, both involving prayer, I think non-denominational prayer at university graduations, and I don't think either of those cases involved a school official giving the prayer, so I'd say that even under those cases, this might still be impermissible. There's also a 4th Circuit ruling, 4th Circuit Court of Appeals ruling, Mellon versus Bunting, that came after the Santa Fe ruling, and it said that even in an adult setting, prayers are not allowed. That it did involve a military university, so there was more coercion involved in the ruling and the reasoning, but the court still said that you can't have prayers in a public university setting that are being endorsed by the school itself. So that actually is all I have time for today, but I look forward to talking to you next time on Legal Tuesdays.